Any other questions?
David,
Yes,
can Congress establish the rules of the convention and the process for selecting delegates?
Well, that's another great question, and it's one that a lot of state legislators have for us. Let me just say this. Legally and politically, we don't think it can happen, and we don't think it will happen. Let me explain what I mean. Article 5 really does not address that issue. It's very simple, and it doesn't get into how the rules of a convention are established. So if a court had to look at this issue, its starting point would be to look at what was the intent of the framers. And the starting point for that would be, what was the whole purpose behind the Article 5 convention process? And if you look at the writings of Madison and others who took notes of the convention, it's absolutely clear that the whole purpose of the Article 5 convention process was to give the states a way to bypass Congress and propose amendments that they knew Congress wouldn't propose. So, to say on the one hand that you've got a process to bypass Congress, and then on the other hand that Congress can impose itself into the process by setting rules, would seem inconsistent, and I think a court would recognize that. Secondly, they would also go back and look at the 1787 convention and the other conventions that were held shortly before that our founders attended. There were regional and limited scope conventions that occurred before the Philadelphia Convention. And they would look at that, and when they looked at it, they would see that in every single one of those conventions, the states called them, the states set the scope of those conventions, the states decided what the process would be for delegations, and then when the delegates or commissioners arrived, they chose what their rules were. So a court looking at this would certainly be heavily persuaded towards that. And in fact, there's at least one case, legal precedent. It was decided, the case is Dyer v. Blair. It was decided in 1975. And the judge in that case was the future Supreme Court judge, Justice Stevens. And that case had to do with who had the authority to set the rules for a ratifying convention. Not the proposing, but a ratifying. They're both analogous. And Justice Stevens made it very clear in that case that the convention delegates themselves had that goal, or had that obligation, that duty, that authority, not the party, not Congress. So we've got that to go. Now, the naysayers will say this. They'll say, well, Congress has the duty to call the convention, and the necessary and proper clause of the Constitution says that when Congress has a duty to do something, it also has all powers necessary and proper to carry out that duty. So they would say Congress could, if it wanted, try to impose itself on the convention by setting the rules and delegates, etc. Well, an equally strong argument can be made that Congress's duty to call, everyone agrees that duty to call is what's called a ministerial duty. And therefore, the necessary and proper clause does not even extend to that, and if Congress tried to do it, it would be acting unconstitutional. That's kind of a legal mumbo-jumbo argument, but it's there. But also, if we look at, I don't think Congress will do something. And why do I say that? I don't think they'll try to impose themselves for the following reasons. Back at the end of the 20th century, there were two movements that came very close to an Article 5 convention being called. There was a movement on apportionment in the 60s in response to the Supreme Court's claiming one person, one vote was the mechanism for states to apportion their legislatures. And then in the 70s and 80s, there was a movement for a balanced budget. And during that time, there were 40, according to one congressional report, there were 41 different pieces of legislation that were dropped in one of both houses of Congress, attempting to come up with some set of rules for an Article 5 convention. None of them even came close to getting passed. If we look at the current lay of the land, we have a divided Congress. They can't agree on anything. It's extremely difficult to believe that they could somehow find a way to agree on a set of rules for this convention. I don't think that would happen, particularly given the history that they've never been able to do it in the past. So, and then finally, the state legislators are already moving on this. On December 7th, 2013, state legislators from all over the country met at what's now being called the Mount Vernon Assembly. 32 states were there. And those legislators started the process of drafting the model rules for a future Article 5 convention. So the legislators, in many ways, have preempted Congress, and they've said, this is what we want. If a majority of the states make it clear to Congress that they don't want Congress getting involved in this, remember, they're telling their state congressional delegations that this is how they feel. Once again, the likelihood that Congress is going to get into this, given that they're already single digits popularity-wise, the likelihood that they're going to pick a fight with the states on this, I think, is very remote. So, for both legal reasons as well as political reasons, I think Congress has no role in this process and the states have total control. But it's a good question.